Mehr Group of Companies, Inc. Jane & Co. appearing for appellant. Ashley Teasdale appearing for appellee.
Good morning. May it please the court. Okay. My name is Jane & Co.
Right.
And I'm here.
You want to reserve some time?
Oh, sorry. Yes, I would like to reserve 3 minutes.
3 minutes. Okay. We actually have 2 matters on appeal, and we're going to get into that relatively quick, but we'll reserve the 3 minutes for you, okay?
Yes.
Okay.
So those 2 matters are being heard as one, I understand.
Yeah, nobody asked to do anything else, and that's what we're doing, okay?
Yes.
Mr. Coe, if I could direct you to start with.
Yeah.
With respect to the sanctions order, which is the appeal in case 1203.
Yes.
The sanctions are against the debtor and the debtor's principal. Moreover, the sanction order was not against you, and neither the debtor nor the debtor's principal have appealed that order. Therefore, I'd like you to start with, if you would, how do you or your law firm have standing to appeal the sanctions order?
The order was to remit or give most of the pre-petition retainer that the council was holding, as well as the fund of the debtor that the council was holding, and the fund that the Chapter 11 trustee was holding. And how the court went about the whole thing was, first there was my application as the Chapter 11 debtors counsel for fee of $91,000 and the cost of $2,300. Had that been granted as requested, I'm not saying it was, most of those funds would have been paid to the council. Now the court talked about at length about how to punish the attorney for being somewhat negligent about allowing the debtor to submit false insurance document. And then the court's solution was, I'll reduce the council's fee from what he requested down to $5,000, including everything. And then the rest of the funds, wherever it is, should go to pay for the sanctions. Okay, and that's why the sanctions is...
If we affirmed the order in 1202, then you wouldn't have any right to the trust fund or the funds in your account, correct? I
would, Your Honor, because I'm sorry.
Well, no, if the judge determines, if we affirm that you're only entitled to $5,000 worth of fees,
yes,
then you'd have, and if that's our decision, if we affirm it, then what right would you have to the funds in your trust account?
You're absolutely right. I would not have any right to claim.
So I would. If you mind, I think it's important for us, at least for me, yes, if you go ahead and address 1202.
The only reason it's pertinent is because our fee application was reduced for the purposes of allowing the Chapter 11 trustee to have most of the funds, and that's where it became an issue for us. The amount of the sanctions was necessary for us to review and argue that it was inappropriate because that was the vehicle under which the total counsel's fee was reduced down to $5,000.
Well, okay. One of the things we're going to get into with your worthy adversary here is the extraordinary deference that a reviewing court always gives to a bankruptcy court's determinations about fees. And the theory behind that is the bankruptcy court was there and witnessed the scope of the work, the complexity of the work, how many issues came up, the skill with which it was performed, on and on and on and on. Based on that, we virtually never second guess the thinking of the bankruptcy court in coming up with the right number. Now, if you want to argue that, well, that just wasn't what happened here, it was not independent, in fact, that's a tough row to hoe, because we just, for any number of reasons, we weren't there. It's an extremely factually intense and almost experiential decision that a bankruptcy judge makes, and what I hear you saying is, well, he didn't really do what he said he did. He didn't really reduce me to $5,000 because the work was not good. He did it for another purpose. If that's what you're saying, you're going to have to help us out with that one.
That's essentially my argument. The fee application was not really decided based on whether the service was necessary and was it at the time actually benefiting the estate. Those standards were not applied. The whole idea behind the fee application judgment was to see if this counsel should be punished. And the whole length of the hearing was about what, if any, can the court do to punish the counsel. And
Let me restate that and see, have you respond to this. If we take out the idea of punishment for a second, okay, and just play with me, the standards under 327, et cetera, and 330 are basically, did you help the estate? So was the work actual, necessary, well performed, so on and so forth. So, that can sometimes be just a simple arithmetic, what's your hourly rate, how many hours, but it can be changed in all kinds of ways because of the complexity or the challenges and so on and so forth. I mean, it's a very broad inquiry. So do you have to really get to punishment to say the bankruptcy court was concerned about the value of the services and therefore arguably reduced it? You might have, you actually did file a monthly op report, there's some utility to that, but it wasn't well done. I mean, couldn't we conclude that the bankruptcy court had discretion to reduce fees because the services weren't well performed? Without talking about punishment, could we do that? Could Judge Clarkson have done that?
many times it is done at the bankruptcy court in a summary way.
Yeah.
But the counsel once has been appointed as Chapter 11 counsel and made an application for the fees timely and properly. Then the court has to review item by item what the counsel did and was it beneficial at the time for the estate. The work that the counsel did entailed affirming about 5 leases and reject.
The judge did say that you mishandled the case. And isn't that enough? If we're going to give discretion to the judge, to the trial court judge, to look at this stuff, isn't a conclusion or a finding that you mishandled the case sufficient for the judge to exercise discretion to reduce the fee award?
No, Your Honor. That is judge's incorrect application of court's discretion to sanction. That amounted to a sanction.
Well, can I give you a thought here?
Yes.
Judge Spraker and I were also on a panel a few years ago with Judge Taylor and Ray Gilman. And I think what we said in that was, number one, there's extraordinary evidence to the bankruptcy court. 2, the bankruptcy court's not obligated to go through entry by entry. The bankruptcy court is obligated to explain why it came up with the number it did. So the question is, do you think Judge Clarkson's explanation wasn't satisfactory, you can say that. If you're telling us he had to rule on every time entry, he didn't, in my view, okay? So help me out with that part.
Well, number one, during the hearing, Judge Clarkson did not allow the counsel to really speak on any point regarding the fee application.
Okay.
Judge Clarkson had a view that the attorney had to be punished, and Judge Clarkson decided that the one motion Chapter 11 trustee, who was a Chapter 11 trustee for 2 weeks, made a motion to dismiss the Chapter 11 case,
Right.
was worth $83,000, whereas the counsel's work for the entire period that entailed reaffirming leases and rejecting leases and proposing plans just didn't have to be reviewed item by item with the necessary standards. It was just a wholesale determination, as if it was a job lot, that what this counsel did, and based on his application, he did spend some money on costs. So I'm just allowing him to have $5,000, but the rest of the pre-petition retainer should be paid to Chapter 11 trustee. That's exactly what Judge said on the transcript. And there was no proper review of what the Chapter 11 debtors counsel did. All the previous applications about the fees, what the Chapter 11 counsel would do, that was determined by the court at the time of the employment application, were ignored. And this is almost as if looking at a job lot by a wholesaler saying, I'll give you $2,000 for the whole thing, as opposed to looking at item by item But the bankruptcy code requires.
But the court did address a few items at the beginning that it wasn't in the format, didn't apply the U.S. trustees' guidelines. It's only in chronology. You can't tell what's broken down into which subject matters. It questioned the ability, the time spent for the fee application, for the employment issues. There are some things there, and I think you even conceded there were some issues with the quality of work in some of those matters, the application, the schedules, and such. So didn't he give some reasons for the reduction?
No, Your Honor. As in the quote that I made in the reply brief, the counsel for the Chapter 11 trustee said, what about punishing the lawyer? The judge said, I took care of it by reducing his fee down to $5,000 and asking him to return all of his, the rest
But you're
of...
reading that one way, and I believe we're suggesting, given the judge's experience with that entirety of the case,
Yes.
setting aside the sanctions, it could be viewed as evaluation of the reasonable services at that time.
That's where I claim is wrong. Court's inherent power to sanction the counsel is there. However, there are requirements. There has to be proper notice, and court has to find explicit finding of bad faith.
But your $93,000 you asked for, that was the issue before the court. There was proper notice about that. And isn't the burden on you to prove that you're entitled to the fees? And this is not, we didn't get into negative numbers. It wasn't denying your $93,000 and asking you to pay more.
Yeah.
We're still dealing with fees because the judge only brought it down to $5,000. He didn't bring it down to a negative number.
Well, as I was arguing, the reduction of the fee really amounted to sanctions, and it wasn't really following any of the laws regarding...
You're almost to 3 minutes. Can I give you a question that you can think about, maybe
Yes,
you can
Your
respond to? In your mind, this is a remand, right?
Yes.
Send it back. If we remand, what direction do we give Judge Clarkson, in your view? What did we tell him to do? And you can think about that and come back to the podium if you like. You can address it now, but you can think about it. It's up to you.
Will do. My thought was that the order of requiring paying the Chapter 11 trustee of all the funds that the council was holding should be reversed. However, and that the council's fee application should be reviewed.
But
With
with respect to what was the error in the review? That's what you can address when you come back, okay?
Yes, Your Honor.
All right, thank you.
Good morning, Your Honors. May it please the Court, Ashley Teasdale, Ringstead and Sanders, on behalf of the appellee, the former Chapter 11 trustee, Karen Sue Naylor. As you know, these are two related appeals from two related but separate orders. You've already asked questions of the appellant of one of the distinctions that I would like to make, which is that if the fee order is affirmed, that's 1202, then the appellant does not have standing to appeal the sanctions order. The bankruptcy court applied the correct standard in evaluating the appellant's fees. The bankruptcy court did not sanction the appellant. The question to which the appellant refers...
Isn't that the problem? You just alluded to that there's two matters, but the problem is the blending of the two.
Yes, Your Honor. It makes it very difficult to keep the issues separate, and it makes it difficult in reviewing the hearing transcript because the court considered one matter and then considered the other matter and then made a ruling on one matter and made a ruling on the other matter, but it all is interrelated.
I think I would agree with counsel's representation that there was not an opportunity for, shall we say, a robust discussion of the fee app. Judge Clarkson came out with a view of things, and they really, for whatever Mr. Coe did or didn't do, he didn't get much of a chance to defend the fee app, and that's a little bothersome. And it does make us concerned that there's just no distinction between, in Judge Clarkson's mind, getting to a number and how he got there, whether it was a sanction. So that's what is on my mind, certainly, and I think you'll hear from my colleagues similarly.
I think that the court was very concerned about the deficits in the initial fee application. The initial fee application was prepared in such a way that it was difficult to understand what fees were being requested.
Well, did Judge Clark say, okay, it's denied without prejudice, let's see a really great fee up next time in a month? No, right? That wasn't the result.
Right.
Part of the problem also, too, is the scope of it, and this is the blending issue. I mean, there obviously was some work, and there obviously was some effort, and if the case had just been dismissed because the debtor couldn't make it, I have no idea if it would be the same result. If the time spent on the plan, if the time spent on the executory contracts wouldn't have generated some fee above $5,000. Is there any way that you can address that? I mean, that's part of what we're struggling with is, can we review that based upon the record?
Well, I think part of the court's concern, the bankruptcy court's concern, was that the way that the fee application was written, and because it didn't set out the specific categories and because it didn't summarize the benefits from each of the specific categories, it made it very difficult for the court to evaluate with more particularity. However, the court did look with some particularity at specific issues. For example, I'm looking at the transcript here. The court said that the appellant failed miserably with respect to explaining what you did in the categories, the billing categories of administration, case administration, asset analysis, and recovery especially. And the court also recognized that the United States trustee did take the time to go through the specific time entries in the fee application. The court noted in the U.S. trustee's opposition that the work performed by the appellant required a lot of redoing. For example, the appellant filed schedules which were deficient, so they needed to be amended. They weren't, or they were several times, but they were still not correct. The appellant filed a plan and disclosure statement which could not have been confirmed. It was on the wrong form. It would have had to been redone. And so the fees for that are of limited benefit to the estate.
But, it's just, again, not to harp on this point, okay, maybe it would have been $6,000. Maybe it could have been $8,000. It happened to be $5,000. And what I think we're struggling with here is this well-established doctrine that we do not want robustly to question what bankruptcy courts do on fee-ups because they know what happened and we don't. And we do not require a line-by-line review. I think Gilman stands for that proposition, but we have to have a good explanation so that we understand what the court did. And the concern we have here is it's just, to quote the old joke, you can't get there from here. I don't know how we got to $5,000. Maybe it's the right number. Maybe we should look at it as, well, that's filing the case in the first 2 weeks of work, which might have been perfectly fine. But that's a big leap for us. Yeah, I mean, that's what we're struggling with here, is how do we get there? And we don't want to undo this notion that we want to defer to the bankruptcy courts, but we want to have at least a pretty good trail for how we get there. So help us with that part, if you would.
The court also, in its review and in making its rulings, the court incorporated all of the analysis that had been presented by the analysis and evidence that had been presented by the United States trustee and the trustee. The court did say that they incorporated their briefing.
Well, that mostly went to wrongdoing, right?
Yes.
Okay, so that sounds like a sanction. I mean, now maybe Judge Carson didn't mean it that way. Maybe what he was saying was under 330, I have such broad powers, you don't have to call it a sanction. It's just harm was done, so therefore I can reduce it. Mm-hmm. Is that how you suggest we look at this?
I'm sorry, would you say that again, please?
Sure, that if we don't have to call it a punishment. There's an exceptionally broad ability to review the good done or the harm done under 330. So 330 doesn't have to implicate a sanction. It can simply be, it's going to be less because other people had to do things and it was not well done, and so on and so forth. If you're saying we should look at 330 that way, that's at least a vehicle to do what you want us to do. Is that the argument?
Yes, I believe so,
Okay.
Your Honor.
All right. So we don't have to get to sanctions.
Right.
All right. So the fact that you relied on something that really went to wrongdoing doesn't make it an analysis res sanctions necessarily. It can make it an analysis under 330.
Correct.
Okay.
And the court specifically declined to issue an order to show cause res sanctions because he'd already made a ruling in
Yeah.
the context of the
Well,
fee application.
there's a lot, some very interesting stuff in the hearings, including what should be the right standard for an attorney looking at a document.
Right.
I mean, I think if Judge Clarkson wanted to, he did not want to rule, and he didn't rule, that you're obligated to look at it the same way the Chapter 11 trustee did and come to have the same, bells go off in your mind. I mean, that would have been a ruling that I think would have had to have been explained a little differently. He didn't do that, and yet it sounds like he keeps coming back to what went wrong here in terms of bad conduct.
Right. Well, and there was a colloquy on the record regarding the patent issues with the bank statements.
Yeah.
And the bank statements, someone who actually reviewed the bank statements with an eye for making sure that they fit with the rest of the monthly operating report, with an eye for making sure that the numbers were consistent, that this was a document that you're presenting to the court as an attorney that presents a consistent picture of
When
what's
would
going
that
on
have
in the
been
case.
done?
Sorry?
In your view, and reading Judge Clarkson's decision, especially as it applies not to sanctions, but to fees, when was that time? Was it, because that was, you're complaining about reconciling to monthly operating reports, which hadn't been done at the filing. So again, to Judge Lavery's point, does that mean sometime from the filing to those operating reports was not tainted by this patent, obviously bad actions?
I don't think that the court found that the appellant did any bad actions himself. I think that the court's concern was that the appellant hadn't fully complied with his duties as counsel for a debtor in
And that's the point I think Judge
possession.
Lafferty was getting at, is we're a little queasy about what those duties are. I understand that by the time it's presented within the sanctions vehicle, it becomes apparent, and Mr. Coe did not really challenge that. But then it's the blending again into the fee app right after that, that it's kind of hard to separate as to there's this duty that he failed. When did he fail it? And does that retroactively apply, or is it prospectively as to the evaluation of the fees?
With respect to the bank statements, I think that he failed it at the level of filing. But that said, he also filed other pleadings. Again, as I mentioned, the petition, the plan and disclosure statement, while he did file the request to affirm the leases, or to assume the leases, the trustee still ended up needing to file a motion to extend the time because it wasn't clear whether all of the leases that needed to be assumed had been assumed. So we filed an extension of time to assume or reject leases. That there were, I think it was a global issue of the appellant having not performed work that merited, that sufficiently benefited the estate, or that merited payment in full of the services that were billed, because they did not fully benefit the estate.
Did Judge Clarkson go through, and 330 talks about the judge can consider the value of the services performed. And, at the time, where did Judge Clarkson say, I've looked at all of this stuff. I've looked at the beginning stuff. I looked at your petition. I've looked at your schedules. I've looked at everything here. I've looked at your fee application. And looking at each of these factors and looking at the problems, the mishandling, I come up with a value. The value of those services was only $5,000. I mean, Where does he tell me that he's taken into consideration the overall package that was presented?
I think that the main place where the court discusses the ruling regarding what the court has looked at it is in the transcript at it's AP 446, line 24 to AP 448, line 15. That's the judge's, where the judge makes his ruling regarding the fee application. And he says that what I appreciate is that the United States trustee did take the time to do that being go through with a microscope your fee application, and realize that it was fairly hopeless to look at your fee application and actually make anything of the categories or the time that you stated or the time that you've spent. And let's make sure that we all understand that on page 4 of the U.S. trustee's objections, especially starting on line 16, where it says the initial set of schedules was materially inaccurate and therefore had to be amended. I mean, from the very beginning, this case was trouble. I will point out that this court itself recognized how troublesome this case would be on simply procedural matters, and the United States trustee was kind enough to attach initial schedules and amended schedules as Exhibits A and B to its opposition. The filing of materially inaccurate schedules that did not include landlords on its schedules F and G were very concerning to the court. So from the very beginning, this case was mishandled, and the court takes note of that. And then immediately after that, he says, I'm going to grant you $5,000 as your total fees and costs. I see that I have about 1 minute and 50 seconds left. Would you like me to address anything with respect to the sanctions order?
Up to you.
Okay. Do you have any other questions for me?
No, thank you.
Thank you very much.
All right. With that, I respectfully request that the court affirm the bankruptcy court's orders on both the fee order and the sanctions order. Thank you.
Thank you very much. Thanks. Okay, Mr. Carr, you got a little under 3 minutes.
Your Honor, most of the objections to fee application was raised by U.S. trustee's office, and U.S. trustee was asked to opine on the fee application and how this should be handled. U.S. trustee recommended to court that debtor's counsel should be allowed to keep the pre-petition retainer, and the rest of the fund debtor's counsel was holding on behalf of the debtor should be paid. At least U.S. trustee's mind, who raised most of the oppositions to the debtor's counsel's fee application, debtor's counsel was entitled to at least that much amount, and that's from the mouth of the very person who made all the objections and all the criticism of debtor's counsel's fee application. So at least the debtor's counsel should be allowed to keep the pre-petition retainer in entirety, reversing the court's order of remitting that to the Chapter 11 trustee.
In the discretion, if the U.S. trustee's discretion, if we're following that, the U.S. trustees was of the position that the fee should be reduced, and the judge was of the opinion that the fee should be reduced. It's just one thought it should be reduced more than the other.
Well, the U.S. trustee also was speaking from the fact that the debtor's counsel should be sanctioned. And the discussion was, as it's reflected in the transcript, what should we do to this counsel? U.S. trustee was saying, with all the problems here in this case, I think the debtor's counsel should be fee should be reduced to the point where his pre-petition fee should be just kept and nothing beyond that. And the court went further. So the standard that was applied to in determining the fee application was really not the 330 standard, but rather how should we punish this attorney?
Do you challenge that the fees should be reduced? Do you disagree with that?
Well, fee is always reduced in most of the fee applications by the bankruptcy court, because the bankruptcy court is sitting in the position of the debtors and say, was it really fair and necessary and et cetera. However, I'm just saying the way it was reduced was
right.
just
But the
not
problem
right.
is, on the other side, is that looking at this, there have been numerous instances pointed out where the work needed additional work, revisions, corrections, or didn't get the job done, which suggests that some reduction was required or what was appropriate.
I would take that as a fair criticism. However, it was The way it was reduced down to $5,000, that's what I'm objecting mostly.
Okay. I think we're at the end of your time. Thank you very much. Thanks to both of you for your good arguments. It's very interesting. Appreciate it. Okay, we will take this matter under submission. We'll get you a written decision as soon as we can. And in the meantime, that concludes our calendar, and we will adjourn, although, as I mentioned earlier, we'll be back out in a few minutes to talk really just to the extons and law clerks who have come here to observe the arguments. So thank you very much.